But the argument is, for example, if you're sitting on your couch not buying something, that your decision not to buy something is, may impact interstate commerce. And it was amazing how the debates went on in the Supreme Court, how pointed they were, because they literally act about this. That if you don't buy a new car, that someone may not have a job in another part of the country. And so the justices were really wrestling with, as they often do, if I accept your argument in this case, where do I draw the line? That's the famous slippery slope concern. Is if I go with you on this case, am I sliding down a slippery slope with nowhere to stop? And the arguments were really about that, and really focused on the fact that there is no limit if this isn't it. Now, part of the reason too is that this isn't very clear is the fact that we've already lost so much ground. Right. It doesn't quite make sense even now to say. My favorite lobbying example is Gandalf in Lord of the Rings saying that you shall not pass. If we say here about Obamacare, you shall not pass, this is the end, we're still in an illogical place because we've been pushed so far against the goal line, against the yard line, that we're really pressed up against the wall as it is. Now, I think everybody conceded that if this is a tax, then we lose, because basically Congress can do anything it wants with the taxing power. They tried to say if they tried to argue, well, they tried to play games with what is the market, and there was a lot of discussion because if healthcare is the market and everybody eventually gets healthcare sooner or later, then the Congress can regulate you sitting on your couch not buying anything, because sooner or later you might. And of course there's also the necessary and proper clause that expands the powers of Congress to some extent. I would say recently that I think that we have stripped the gears of the constitutional mechanism a long time ago, and even the necessary and proper clause has been vastly overexpanded. Part of this too, before I forget, let me point out that although we learned about the Supreme Court being the guardian of the Constitution and how they stand up for the Constitution and hold the Congress accountable, that's not really how it works. Because what happens is while the Supreme Court says we decide what the Constitution says, they also have all these gimmicks to bend over backwards to do whatever the Congress says. So if the Congress has a finding that says the moon is made out of green cheese, the Supreme Court will assume that that's true when analyzing the law. They'll say, well, okay, assuming that their findings are correct, we're not going to challenge them. They're going to say, we're going to presume that they're right. We're going to give them the benefit of the doubt over and over and over again. So really, when it comes right down to it, the Supreme Court is often a paper tiger. And it's been said that's partly because they don't, people jokingly said, how many armies does the U.S. Supreme Court have? None. So all they have is their ability to issue paper, and they do it very, very judiciously. The reason I remain hopeful here is that, again, I think they know that there's nothing left if they give in on this one. So I think this may be like a football team on the 3rd-yard line, where there may be more resistance to completely giving up on this. There has been an attempt to breathe more life into the 10th Amendment and put limits, and some justices have been trying to do that. Let me also point out that you will hear, especially in the media and discussions and liberals, the idea of an activist court. And I just want to make you be aware of this, because an activist court, well, actually they know better, but they're deliberately trying to confuse the issue by saying an activist court is when the courts strike down a law by Congress. No, that's not an activist court. A court that requires the Congress to stay within its boundaries is not an activist court. That's just doing its job. An activist court is one that makes up new policy or makes up new law. But they've tried to turn that phrase on its head in order to intimidate and confuse conservatives, so that when the court does its job and says, no, you can't do that, they try to intimidate the courts. Oh, you're being an activist court, and you conservatives don't believe in that. Yes, we do, but we believe in the Constitution. So that's part of the problem with that. However, now I was going to say about, lost my train of thought a little bit, but the concern I have is that when you read the Supreme Court opinions, how you frame the question, like in politics, but perhaps even worse, decides the outcome. So they will be debating back and forth, you know, is the market health insurance? Is the market all health care? How do you frame the question is going to decide what the answer is. And they'll be trading these draft opinions back and forth, trying to entice one more vote, trying to, you know, they know what the pet peeves are for the other justices. And some justices might think, you know, it's kind of like horse trading. I don't really care so much about this point, but I've been itching for a chance to make a point, to make a statement about something or other, and so they'll try to put an opinion in front of them that entices them to sign on to make some other point. Like, you know, in antitrust law, how you define the market goes back and forth, and so it's like, well, I can make my point on that now here, and a lot of the argument on C-SPAN and in the court was about the idea that it's a timing question. It's like, well, if the person shows up at the emergency room and has to buy health care, could the Congress say you cannot get medical care without having insurance? And again, that's where I feel like we're fighting over crumbs. People say, well, of course they can do that. They can say you may not have health care unless you have insurance. So if Congress had simply written the bill a little bit differently, it would just sail right through. And so they were trying to argue that, well, since Congress could have done that, they're just getting at the problem a little bit earlier in time, so it's okay. And that's what some of the argument came down to, is just well, we know sooner or later they're gonna need health care, and you could have regulated them then, so it's okay now. And they, of course, repeatedly people tried to point out, you know, some people in the back and forth, justices and lawyers, that, you know, healthcare does not consist exclusively of people showing up at the emergency room. You know, that's only one small stereotype of healthcare, and of course there was some discussion back and forth about whether the policy of making people subsidize others was an issue, and they say, well, everybody eventually needs health care and that kind of thing. You know, and like I say, very, very little attention to the fact that, hey, you're only supposed to be regulating interstate commerce. This isn't interstate commerce. I think somebody at the event I was in last Sunday raised the question of if the Congress has the power to regulate international commerce, so does that mean that they have the power to force another country to enter into commerce with us? Well, of course not. So how is it that you can force American citizens into commerce? The better to regulate them. And there was quite a bit of discussion about whether or not Congress can regulate a market that already exists, which again I think is the wrong. The power is to regulate commerce, not whether or not a market exists. But they discussed a great deal about the difference between whether Congress can create a market that didn't exist and then regulate it, or if they can merely regulate a market that already exists, and they say, well, everybody sooner or later gets sick. Well, maybe, you know, maybe not. But so therefore you're already in the market, and therefore it's, hey, what the heck, it's okay. And again, one of the troubling aspects of that, again, is how far we have already lost our principles, because I don't really have a strong feeling about a national bank myself. I really haven't made up my mind one way or the other. But apparently, in the case that upheld the national bank, they did struggle with this, and they said, well, can you create a market? And they said, well, we've already, you know, that basically argument is already lost. Some people tried to argue that, yes, they can create a market. But somebody else pointed out, well, if you can create a national bank, but you can't force everybody to put their money into it. So those are some of the reasons why, as I say, this could be sliced and diced so many different ways, and it could come down